Welcome, everyone. How you guys, everyone, doing here? You okay? Perfect. Well, my name is Kashif. My friend called me Cash, like cash money. I can also accept a Venmo, credit card. I was expecting a bigger laughter. Sorry about that. So I'm a founder of a company called DAOhelper.com, and what we are hiring a discovery platform for DAOs, NFT projects, protocols, and you can set up your on-chain resume with verified credential on our platform and match with opportunities that is according to your skill set level. So there's something a little bit about DAO Helper, and we are in public beta, so you can go on DAOhelper.com right now and set up your on-chain resume. So I will let my guests introduce themselves from here.
Thanks, Cash Money. My name is David Kerr. I'm an advisor for a series of DAOs. I have an advisory practice, and I'm also the head of research for the DAO Research Collective, which is a charitable organization that sets up grants and funding measures to help kind of bring forward the academic writing in the space. They do a lot of subsidies for people writing papers that are useful to the space, and so we help coordinate topics with them, help them get peer review because that's hard in a field where maybe there's not a lot of known contributing authors to a space, and then help them with their publications. And then probably my highest profile work has been in a partnership with a friend of mine from law school from ancient 20 years ago. Miles Jennings is the general counsel of A16Z, and we've written a series of papers on DAO legal entity structures and domestic entity structures in particular, the Unincorporated Nonprofit Association. And then I'm on the Treasury League for FWB. I was an advisor, and I ended up just joining the DAO, and then I service a series of other DAOs on the domestic tax needs, tax strategy, entity structuring.
Hello, my name is James Wigginton. I am an attorney with the law firm Orrick, and I am a member of the blockchain and crypto practice, and we do all sorts of different things within that practice, but my focus is primarily on DAOs and DAO structuring. And just by way of background, I started off my career at a Wall Street law firm doing a lot of securities and M&A work, and then I left that world for a while and went to a much smaller law firm in Sacramento where I did work with agriculture and with farmers. And some of the lessons that I learned there are directly applicable to DAOs. And so that was sort of my bridge from from what I was doing then to what I'm doing now. So I work with DAOs on structuring issues, and I'm particularly interested in the nonprofit form and the cooperative form. And so that's been a lot of the work that I've done.
Hi, my name is Lisa Rubin, and I work at Paul Hastings. I'm also a blockchain attorney, and so I focus more on the federal securities side, but we also work with a few DAOs. And so some of the things we do is help large companies like exchanges. We will review their token before they get listed on the exchange to see how risky they are, and also working with founders and emerging companies, either if they need help with entity formation or they're designing a token or some kind of service. So just kind of helping founders build and avoiding legal risks under the law. And additionally, investors who are interested in Web3 but want some kind of regulatory guidance before they dive in. Thank you.
Thank you, everyone, for the introduction. So we're going to get started here. First question for you, David. How the DAOs are structured today, and follow-up, kind of supplementary question to this, why DAO should get registered, like why there is a legal entity that is required for DAOs?
Yeah, I mean, that's kind of a threshold issue for kind of the DAO space. And so it's helpful to kind of look back over the 5 years as a retrospective and kind of get a sense of kind of where DAOs came from and how they came to kind of be thought about existing. The early DAOs, for the most part, I would say the predominant any form, and you still find it today, is entity-less. that there's some fundamental arguments that in a lot of ways they don't have some of the same characteristics of companies. They don't have some of the same characteristics of entities that do need to be structured. And they're obviously geographically diverse. I think the most helpful lens to start thinking about DAOs would be, we've accepted a very loose definition of what a DAO is. And really honing in on that is really important when you start getting to the specifics of how they're going to be treated for legal purposes, how you look at them for tax. And so the bucket that I use, and that's not definitive, a lot of people would probably do it a little bit differently, but I look at what I consider a native DAO and a protocol DAO. And so a native DAO is a DAO that's formed you're building the airplane while you're in it. You have some kind of decentralized process, you come together as a social club, you might connect over a few smart contracts, but for the most part, you're relying on the blockchain technology to help support decentralized communities. A lot of the passion around DAOs is around that kind of work, because historically, decentralized communities haven't had a particularly good track record against centralized processes in government, in business operations. Centralization's faster, it's more efficient, it's more dominant when it's faced with competition, because you have an agile structure that makes decisions, and decentralization from a social standpoint is a lot slower. The advent of the blockchain supports a robust decentralized technology, and I think a lot of folks are excited about the possibility of exploring forms of governance that kind of follow along that principle. In stark contrast to that would be what I would consider to be a protocol DAO, which is a series of smart contracts, certainly more than two, that usually execute a function that provides some kind of service, whether it's a decentralized exchange or a bridging protocol. There's any number of technological solutions, but there's no need for governance, really. The smart contracts exist. They were developed external. They found a way to release a token that created a treasury. The investors were able to retain some of that token. The founders created some of that token. But for the most part, you've got this decentralized token in the hands of folks who were, at the time, unrelated to the project. What they have control over, more or less in most cases, is the treasury funds, the other tokens that have ended up in the treasury. And they can make funding decisions around those tokens to help support the protocol, help make decisions around grants, but they're not operating a business. The analogy that you would look for is that they're more like a municipality. They're keeping the trains running on time. They're not having to make active decisions. It's a flat organizational structure, and if they're not generating fees in any way, then their need for legal entities are actually pretty low, in the same way that layer one technologies mimic HTML or other baseline services from Web 1, where it's a protocol. It's a piece of code that doesn't do anything. The introduction of tokens brought in the introduction of value. And so even though they're not an equity interest, even though we're not talking about ownership, it's a totally false comparison to start referring to that as stock, because it doesn't carry any of the value transfer that stock does. You still have the ability to now control something that has value. And who the people are, where they're located, their citizenship, all of that factors into, do they have a tax obligation, do they have a liability obligation? And the more you have control over, so the native DAOs are almost certainly in need of an entity, and protocol DAOs, depending on process, start drifting towards needing one. And so you're tied to physical presence rules, you're tied to citizenship rules, and you have income that's being controlled. Even if it's not being distributed back, you have possession of that income, you make a choice with other people collectively where it goes, and now you've introduced taxation. And so, in a lot of ways, a lot of the funding that goes through DAOs is US, a lot of the participations in the US, or there's clear delineations for projects that have no US contacts. And so that's another huge threshold issue for looking at where entity structure is, what jurisdictional rules can apply or do apply. And I would say that the US is extraordinarily aggressive in making US policy known around the world in terms of both their securities reach and their taxation reach. But at the same time, there are other aggressive tax markets, there's other aggressive rules, and so it's a really difficult decision to try to figure out how these geographically diverse groups of people who are pseudo-anonymous in a lot of cases, what jurisdiction they fall in. And so that's kind of my come to the issue, high-level view of that.
So just a follow-up question.
Sure.
I understand there is a lot of variables that you kind of mentioned, like citizenship status of the DAO members and everything. But there seems to be two camps in the legal community also. Like some prefer Cayman, like there is a mixture of on-chain, offshore and onshore entity. Some people prefer Wyoming DAO, Wyoming LLCs, mixed with Cayman, BVI, Panama, like Singapore entity. So I want you to touch on that a little.
Well, no, yeah, so that's fair. I think that's where the time period retrospective comes from. When these were launching as ICOs, when these were being done in a way of fundraising that looked like you could do direct sales of token, there was a huge incentive to have that occur outside of the US from a tax saving standpoint. So I'd say historically, 5 years ago, that's probably where the initial step towards Cayman came from, was that is a known strategy for avoiding US taxation. It's a good one, it works. The reason we kind of went away from that is after some of the SEC decisions, it became clear that that just wasn't a particularly effective fundraise mechanism from a security standpoint. And we had this implementation, this Cayman Foundation in place that worked. I think it got modified for a lot of projects. Some of the initial, large DAOs, protocol DAOs, found themselves as Cayman Foundations. And the question would have been, would they have needed to be an entity at all? And a lot of times the answer is probably not. Their fact pattern was a little different than, I'd say, a native DAO. And then I'd say that what happened was there was a lot of kind of copycat, as tends to be the case. And then we had this huge just onboarding of folks to the Caymans, because at the very least, there was a path known for how to get your DAO registered, and it provided some comfort on security, some comfort on tax, but it really depends on your facts and circumstances whether or not the same analysis that makes it a good idea for one company is for another. If you have US actors, US citizenship, US operations, US business, you have a US tax issue, and whether you're in the Caymans or the Marshall Islands or anywhere else, you have to worry about U.S. sourced income. And to the degree that you have that, you need to have a domestic entity. And so that's kind of where the Wyoming DAO came from. That's kind of where the Tennessee, Vermont has a blockchain one. But at the end of the day, I think no one really loves those DAO LLC laws super much, because they're pretty restrictive. They don't provide a whole lot of value you can't get from an LLC. And the real issue with both of them, in my opinion, is the Corporate Transparency Act that requires you to register with FinCEN on your percentage of beneficial ownership requirements, and that's going to be very hard for pseudo-anonymous entities to do. And so the reason why the UNA was suggested by me and Miles as a possible solution to this is they don't have to register with state governments, so that steps it away from needing to comply with the CTA, and that is a pathway to not keeping member listings and having anonymous users. So we just imported a lot of information, but that's kind of the baseline. But depending on, there's tons of DAOs who can use LLCs. There's tons of DAOs who can use LCAs. There's tons of options here. There's no one right answer, but it depends what you want to go after. If you need anonymity, your options are limited. If you need to have distributions, your options are limited. And within that framework, you kind of have to find your path.
That's amazing. You guys want to add anything to this? No. Okay. So. James, you experimented previously buying the Broncos DAO, an NFL team. You want to share your experience in that process, playing with different legal entities to buy an NFL team? We want to hear from that. Yeah.
You bet. Okay, so by way of background, I'd actually be interested, by raise of hands, how many of you have heard of Buy the Broncos DAO? Okay, my colleagues raised their hand. Yes, thank you. Okay, but some of you have heard of Buy the Broncos. Okay, so by way of background, Buy the Broncos was a project, and I say was because it's over. The reason it's over is because the heir to the Walmart fortune scooped us. He's worth somewhere in the order of $68 billion. So buying the Broncos for around $4 billion was chump change for him. And I'm referring, of course, to Rob Walton. Anyway, this was a project that I had been working on since around February. of this year, the idea was to use a DAO structure in order to buy a minority stake in the Denver Broncos. The Denver Broncos were for sale by the Pat Bowlen Trust. Pat Bowlen died a few years ago, and they needed to liquidate, so they hired investment bankers to sell the team. And we thought, and by we I mean a group of sports and crypto enthusiasts, including myself, thought it would be a fun idea to try to purchase a portion of the team as a DAO. And so we started thinking about legal structures to be able to do this. And I think, something that has been at the forefront of my mind, I think David, you're right. There are a multiplicity of variables that go into the analysis of what sort of entity type to use, right? You can be concerned about anonymity, you can be concerned about limitation of liability. My main concern when thinking about the structure of a DAO to purchase a piece of the Denver Broncos was the definition of ownership. I think sometimes in the space we can kind of water down what ownership actually means. From a legal standpoint, and I'm sure there are people who have different definitions, but my working definition of what ownership means is three things. It's governance, it's access to profits, and it's access to liquidation value. Those are the three pillars of ownership. And that's what you get, for example, when you own a stock, right? If I purchase or sell a stock, I have access to profits, I can vote, I receive a proxy every year. And so as we were thinking about how to structure this DAO from a legal perspective, because there had to be a legal entity, right? In order to enter into a contract to purchase a team, you absolutely have to have a legal entity, full stop. No one's going to do business with you if you don't. And so, as we were looking for legal structures, my mind harkened back to the work that I did with farmers. So farmers have been using the cooperative structure for well over 100 years. And cooperatives are very interesting things. They are similar to corporations in that they give you limited legal liability, in that they give you access to those three things, right? Governance, access to profits, and liquidation value. They give you all of those things, but a cooperative membership, if structured correctly, is not considered a security under US law. Now, let me explain why. All of you are probably familiar with the Howey test, the definition of an investment contract. And the essence of that test is that a contract or an investment of money where you expect some sort of financial return from the efforts of others is considered a security and is subject to registration under US law. A cooperative membership interest does not fit that definition. Why? Because in order to realize any value from a cooperative, you actually have to participate. So when I was explaining this at the outset of the Denver Broncos project to people, I said, I called it the butts in seats principle, right? If you are a fan of the Denver Broncos, the only way that you make any kind of financial return is if you actually put your butt into a seat. If you go to the game, if you purchase merchandise, if you stream Denver Broncos, media. And, in a cooperative, what we call that is patronage, right? So if I am a member of a cooperative and I use the goods or services produced by the cooperative, or if I provide goods and services to the cooperative, that's called patronage. And any margin, any net earnings that derive from my patronage can be refunded back to me, right? So in a cooperative, instead of shifting profit from the consumer to a shareholder who is generally passive, in a cooperative, that profit is shifted back to the consumer, at least in the case of a consumer cooperative. And so, from our perspective, the cooperative offered some really sound advantages to any other legal structure that we could find. Because again, it offered true ownership without the cost and without the time that would be required by an IPO. And so the Denver Broncos project died, unfortunately, but we have kept going forward, full steam ahead, researching this model and talking to other sports teams, right? The idea is to democratize ownership, to make it available to everybody, and to reward people for their participation. And I know that's sort of a paradigm shift, right? A lot of us think that ownership means capital gains, right? I derive value from my ownership of something by trading it up. That's not really how you make money with a cooperative, right? With a cooperative, you don't really make money, you save money, right? Instead of somebody taking a profit from you, you're simply being refunded back the money that would otherwise have gone to shareholders. So it's a different way of thinking about the world, but it's extremely efficient. We don't have time to talk about tax, but there are also some very incredible tax efficiencies that come along with using a cooperative structure. So that's probably not quite as exciting, Cash, as you were hoping for. You were probably hoping for some really great stories about like Russell Wilson. And maybe those will come in the future, but you know, I'm still devoted to making this work, right?
Yes. It is very exciting to me because DAO is sports is exciting and everything, but DAO is something that I get excited about. So that legal structure, the cooperative legal structure that you are trying to discover or you're trying to create is really interesting. I think the best example of a co-op is RAI, right? RAI, the sports goods store, that you buy something, you automatically become a member, and you get the dividend after that, right? So I know that you're working on kind of legal framework, DAOs as, correct me if I'm wrong here, DAO as co-ops, right? So we'll be looking forward to see that research paper or whatever form you put out to.
So just to repeat the question, where do I see that going, or?
Yeah. Okay. Where
Okay.
do you see this one going, and what kind of legal framework? Are you going to put out a white paper or a research paper,
Yes.
something out there?
Yes, so we're working on a white paper. You know, I guess one of the problems that I see with the industry right now is this dilution of the idea of ownership, right? Ownership, this concept of ownership is foundational to what Web3 is. The ability to own not only the things that we produce, but also the tools to produce them, right? And I think that in a lot of the conversations we're having about ownership, we're not being precise with how we're defining it. And when you're not precise with how you define ownership, you can make it mean almost anything. So I can sell you something that's really just a product, and I can say, you're an owner now, and you might not question that. Even though owning a specific NFT or token doesn't give you governance and profit and liquidation value, I can still say, yeah, I'm sort of an owner, right? And I don't think that's entirely accurate. And I think that causes a lot of trouble with the way that we think about these problems. And so my hope is to help people become more aware of the cooperative form. You know, cooperatives are everywhere, right? It's not like this is something new. It's not like this is something even all that exciting, right? Every credit union that you've ever used is a cooperative. As you said, REI is a cooperative. Every mutual insurance company that you've ever, you know, gotten insurance from is a cooperative. They're everywhere, but they are not as, they're just not as well known. And I think part of that, honestly, is because they just don't teach about them in law school. They don't teach about them in business school. And so I hope that we'll see a lot more.
Can you layer in the blockchain component of the cooperative? Because right now what you're describing is a fairly traditional cooperative. What's the Web3 element? What's the blockchain element of your proposal?
So, you know, in my view, blockchain is an extremely efficient way of organizing humans.
No.
Are we okay? Yeah. It's an efficient way of organizing people, of raising funds, and of making collective decisions. So, blockchain at its essence, at least, and again, we can all have our own views on what this actually means, but blockchain is a way of tying individual human beings to transactions, right? It's a way of tying identity to exchanges of value. And that is really what a cooperative does, right? You have a unique person who's a member of the cooperative, who is engaging in business, who is engaging in transactions. All of this needs to be recorded. And once recorded, these transactions serve as the basis for the refunds that you receive. So I see blockchain essentially as an organizing force to allow people to make collective decisions, to engage in economics with each other, and ultimately to decentralize power, right? One of the advantages of a cooperative is that instead of shoveling all of the money to the top, it shovels money back to the users. And so there's less of a concentration of wealth and influence at the top that there might otherwise be.
Awesome. Thank you, Lisa, for patiently waiting. Do you want to weigh in any of that cooperative discussion? I have a specific question for you also, but if you have any thoughts on
very
that.
exciting.
Okay. So we started talking when I saw this tweet that you did about CFTC chairman ruling that any DAO member who participate in a proposal and vote on a proposal, they can be held personally liable. So my argument or question was that publicly traded companies and their shareholder also vote internally, right? So why there are two standards for DAOs and for publicly traded companies differently?
Yeah, so I actually get that question a lot. Just if a shareholder who votes in a company doesn't have personal liability, why is it that a DAO token holder could potentially have liability under the CFTC settlement order? And the reason is because the law doesn't recognize a DAO. So even if you are acting, or you think that you act like a corporation, you have to take the additional step and actually choose an entity, file the paperwork, put someone as the person of contact to, if something goes wrong, the state can contact them. So that's why a lot of people, I actually got this question a lot, are pretty confused. So the CFTC order, which I'm sure a lot of you have already heard of, the CFTC, there's a lot of things in this order, but the interesting part to me was they said for the Oki DAO, if someone had a token and they voted the token, they were then part of generally an unincorporated association, so they were then responsible for the DAO breaking the law. And because of that, the CFTC could then theoretically, under their theory, go after anyone who has a token and then votes with that token. So it's obviously an alarming case for many people, but it's a settlement order, so it's not a court order, so it has limited enforceability, but it is interesting to see how it's been thought of. But the thing is, even before that, if people, as my other two panelists have said, even before this CFTC order, if someone is operating in a group and they're doing business for profit, they could be considered an unincorporated association and generally have unlimited liability, and which is kind of scary because you think you're in a DAO, you think perhaps you're protected, maybe you sign a contract and you think that you're signing it on behalf of the DAO. It's possible that you could just be signing it on behalf of yourself. So it's really important that whatever entity structure someone chooses, that someone goes the extra step to select a type of entity that's recognized under the law, because the law will give protection if you file the paperwork, if you follow the corporate formalities, whatever form you choose, whether it's onshore, whether it's offshore, or maybe a combination. And if you follow the formalities, generally the law will respect the personal liability aspect.
It's probably worth pointing out that the theory of liability that was put forth by the CFTC is fairly aggressive and radical. Unincorporated associations was a term that was very common in the 1970s. General partnerships, limited partnerships were commonly referred to as unincorporated business associations. And what happened in the 1970s, 1977, Wyoming, a lot of good developments out of Wyoming. the first LLC. And so the historical form of the LLC was really the first establishment of what was considered a hybrid entity. Prior to that point, you had incorporated entities and unincorporated entities. Unincorporated entities had no legal protections for its members. Incorporated entities is where you found the existence of limited liability for the operations of an organization and the ability for legal existence to exist in the corporate form. Since then, we've had some pretty aggressive expansions of that hybrid concept. The LLP, the LLLP, the LLC, the UNA, the LCA, these are all unincorporated associations that have other paths to the law for their recognition. So you can't say an LLC needs to follow the rules of an unincorporated association because they have existing state laws for LLCs that they have to follow. But at the same time, an LLC is technically an unincorporated association. So when the CFTC came out with their theory of liability around an unincorporated for-profit association, it's kind of an obscure way of defining a general partnership. And so you have to theorize, well, why didn't they just call it a general partnership? Because the unincorporated nonprofit association, when you have two people in an association for a common purpose, if they're for-profit, it's a general partnership. If it's nonprofit, it's an unincorporated association. It's the very general terminology of those terms. CFTC introduced an unincorporated for-profit association, and it's an interesting reason why. They followed a path for the theory of liability around voting where they didn't have to talk about the protections that exist for general partners when they actually do unlawful acts who didn't participate in the unlawful acts. The CFTC wants to hold everyone responsible as if voting was the same thing as breaking the law that UKI did or potentially did. And they don't necessarily want to have to prove the members who voted were responsible for that harm. And they avoided having to talk about how hard that would be to do as a theory of liability by using this case called Heinfeld-Hogg, where it theorized that an unincorporated association making money could be a for-profit enterprise. And that's not the test. The test is, do they plan on distributing that profit to each other and actually making a profit? So it's not exactly a good faith. By the way, I'm advisory, so I'm not a practicing attorney, and so I'm afforded a little bit more discretion in how I talk about things than my colleagues on the stage who are attorneys. So I'm going to be the one throwing the flamethrower language, and I don't think they're going to be necessarily agreeing or even commenting. So this is definitely just me here. But I think the point of it is that it's a notably aggressive action on the part of the CFTC that speaks to the regulation by enforcement, and it speaks to strategy. They also sued under the principle that they couldn't pass service on and had to find it through a chat app because they couldn't find anybody in the DAO. Well, they had two people who founded the DAO, and they knew who they were, and they let them settle. So they strategically created the situation where they then created their own service process to bring forward this theory of liability. That's not a good faith move under any way you look at it, and so you do have to look at that from a regulatory perspective and wonder what the point of the CFTC's action is and how that kind of pairs up with the SEC's version of enforcement. And not to just rain terror into the hearts of everyone coming to the holiday season, but it's worth pointing out that the IRS commissioner, Commissioner Rettig, is going to be stepping down from the post at the end of sometime in November, I think before Thanksgiving. And so we're going to have a new commissioner of the IRS, and the SEC has been very, active in the enforcement actions. The CFTC has stepped up recently and been active in the enforcement actions. And although I think conspiracy theorists view the IRS have been active because there was a lot of John Doe summons around individual service and the settling of a staking income case instead of letting it become litigated, there's some people who view that as like heavy enforcement action. But I would say, it comes from someone who comes from background in tax, it's a very light touch. And if we get a new commissioner in there who matches the same kind of general attitude of a Gary Gensler, then the IRS could very quickly become the biggest issue facing DAOs and Web3 and not have it be the securities concerns that have existed to date, because there's a lot more potential for problems and there's a lot more potential for enforcement action. So it's something to keep an eye on from a regulatory standpoint, that the situation at the IRS has been relatively peaceful, and there's a inflection point coming up that could very well result in that not continuing to be the case. So we want to keep our eye very closely on the IRS.
And based on that point, there is, as you mentioned, November elections are coming up. So that will be also interesting to see how it affects the legislation. There has been over 20 bills or proposals that have been introduced into Congress about crypto and digital assets, about numerous things, whether it's tax or securities or really a bunch of different topics. But since elections are happening this month, there's likely not going to be anything that passes before the next session of Congress. But it is interesting to see that Congress is paying attention to crypto and digital assets, and they're thinking about it, they're learning about it, they're trying to create legislation so that hopefully people feel comfortable innovating in the US, but also that investors are protected at the same time. So there are some big laws coming. As I'm fairly interested in the securities aspect, there are some laws that touch on the definition of securities, which would, if something is a security under the Howey test, as James mentioned, then it would be regulated by the SEC and Gary Gensler, and a lot of people don't want that, so a lot of projects are trying to figure out how to build without being subject to securities laws, and right now the legislation that is proposed doesn't fully define it any further than the Howey test, so it's likely that even if the proposals are passed as without any amendments as currently are, then we'd still probably be using the Howey test.
I was aware of 4 bills, 4 proposed legislation, and you mentioned there are 20.
Yeah, there's over 20. There's probably more like 40, but I was saying 20 to be conservative.
Wow. So, David, you go to Washington very often and do some lobbying. So, any idea what is on those bills, where it's going, where it's coming from?
Well, to be clear, my lobbying work is more limited to state actions from a crypto perspective. And so, and the reason why that is, this being an entity structure panel is, when foreign countries are passing laws related to how they handle crypto, they pass a law and in any form at the same time, because the United States is fairly unusual in the fact that we have, a pretty large separation between our state and federal authority. And our entity structures run through the state, and our federal securities law and taxation flows through the federal, and then the state's a byproduct of that taxation, or sometimes it's its own securities law, and it gets very complicated very quickly. And so when a federal law gets passed related to all of these things, it doesn't actually touch on the foundational structures for the state. So if we need to start building out entity structures that are more supportive of the field, then that's what you can point to as the success of the Wyoming LLC and the Tennessee DAO. Tennessee is actually not an autonomous; it's a decentralized organization, so it's a DO. And the success there is that those states is where we're going to find the options for expansions of our existing entity forms. And so from the standpoint there is we need to start building safe layers as we build this out. And so one of the things that's missing is a entity form that's universally recognized that meets the needs of a DAO. So to bring it back to the more specifics, there's a tremendous state obstacle in front of us. And then on top of that, is when we start having more of the regulation-based bills that Lisa was kind of very correctly about how broad they are. That's where you start getting into money transmission specifics. That's where you get into reporting reporting obligations. Definitional changes. The IRS is looking to change their definition of digital assets finally, and so there's a lot of federal administration. What I would say about where we're at in the future of the Loomis Gillibrand and the other large, high-profile ones is that as much as we in the space kind of live and eat and breathe this 24/7, and it kind of becomes consuming because there's so much to keep track of, and it becomes kind of a part of your life. Part of where the SEC regulatory idea is coming from is that they don't spend a lot of time on crypto, so they use very high-profile enforcement actions to kind of curb behavior that they don't like. The CFTC made a splash, and so when you view it from the fact that they're not actually allocating a ton of their resources to crypto, that trickles up and down from the Congress. Yes, crypto is important, but crypto is only important so much as it brings in votes and wins elections and becomes a threshold issue, and it's not anyone's top priority in Washington right now. And so we view it as this coordinated assault against crypto, and it's really benign neglect. Like, it's not a top priority in anyone's legislative calendar. I don't think Loomis Gillibrand is expected to get looked at until the next legislative calendar, is what I've heard. And the DCCPA kind of pop up, and they're poorly thought out laws that could have a drastic impact on crypto. And then everyone needs to sound the alarm to let people know, like, we need to think about this more, we need to slow it down. But no one's necessarily out to try to stop crypto as a full-time job. I mean, the most well-known crypto critics would be someone like Elizabeth Warren, who hates 9 other things just as much. And so she has to split her attention between all of that, right? And so that's kind of a way to start thinking through this. It's like no one's out there talking about his crypto as much as we are. And so the educational part's real, the strategy part's real, but I think part of what gets frustrating from us is we see the developments in the space and the lack of stable building blocks. And if people committed a little bit more time to understanding it and to building those better blocks, we'd be able to develop a little more cleanly, a little more fairly. But I don't think it's a coordinated effort to stop crypto. I just think it's just not that important to Washington at this time.
Awesome. So I have one last question that brings me, and I want kind of all of you weigh in on that. And after that, we'll open it up for the community. If you guys have any question, feel free to ask that just in a bit. So there is this narrative. There was a book, The Network State by Balaji Srinivasan, and there is a narrative that DAOs are not creating corporations. DAOs are creating new countries, and the smart contracts are the constitution. So there is this narrative. I want you guys to weigh in on this. Lisa, you want to go ahead?
I think that's an interesting comparison. I personally haven't heard of DAOs being compared to countries, but I do think that's very interesting. I think that there are a lot of different creative ways, which is why it is so exciting to be a lawyer in this field, is that you get to work with clients that are building new technology, and you're helping create new structures that help your clients build and hopefully don't ever have to end up in litigation or court themselves. So I would say generally the right structure for each DAO perhaps is different, and there could be a combination of a Delaware C Corp or a Cayman Island or some kind of, it really depends on what each DAO does and where the members are based. Are they based mostly in the US? Are they based abroad? And generally, do they plan on, if they have a token, selling to US customers, things like that. So there is a lot of factors to consider when deciding what kind of entity formation you want to do for your DAO, but it is a very exciting space.
I think that's a super interesting question and not one that I can answer. But I do think it's interesting that in this practice area, I have had to think more about the meaning of money than ever before, and what it means to have a monetary system. One thing that I'm really looking forward to seeing a lot more of is crypto commerce. And what I mean by that is, the purchase and sale of goods and services, without, maybe less of a focus on financial transactions and more of a focus on, the purchase and sale of stuff, right? And I think in that sense, this is coming to, to answer your question of whether DAOs are countries or corporations, right? I think that an ecosystem of DAOs that has a common currency does sort of start to look like a country, right? In the sense that you have this group of people, this community of people who are united by a common currency, who are, selling and purchasing value from each other, which sort of creates, at least in my mind, theoretically, a closed ecosystem that could exist across borders. Right, so we could at some point in the future, and we probably, well, not probably, we actually already are selling goods and services across borders. And I would be I'm really interested to see how that develops in the future, and what role cryptocurrency has to play in uniting these ecosystems of commerce. So I know that's sort of a vague answer, but it's probably the best I can do.
David, I'm really excited about your answer because you're not practicing.
Yeah. I think it's going to be consistent with the rest of it. I mean, is it a corporation? No. No. I mean, that's such a false narrative in the sense of it goes to what James said. You know, the opposite side of the coin of his ownership around the cooperative structure is that the Web3 DAO model also exists for the absence of that ownership, and that's why the comparison to stock doesn't work. And all we're talking about is governance. That's what opens up the door for stakeholder capitalism. That's what opens up the door for kind of the promise of Web3 and the foundational technology layer that will allow an alternative to the platforms of Web2 that have the ability to censor their users, that have the ability to exert control, to deplatform people. What we're talking about here is like privacy and freedom. And so I think on the one hand, I don't want to be super negative on people's analogies that get them excited about the space. But the tent is wide, everything's a DAO, everything's Web3 is also not helpful language from when we're actually talking about Web3. Like some of the technology that we're talking about here works better on the internet, and we're going to live in the future of the internet, and we're talking about cryptography, and we're talking about privacy. And so it's Web3, not World 3. And like, although there are interesting legal arguments for the owning of assets in the real world, the question there is, should that be a DAO or should that be a co-op? The reason why DAOs exist in the truest form is to oversee that very thin hierarchy over an existing platform. And if the idea is there, it's like a city, it's probably more right, in my opinion, of like that true definition of a DAO, because what we're talking about is a municipality. We need something to decide not how it runs, but what we're gonna authorize, what we're gonna do together. And we're not sitting there running all of the we're not running a business. We're not making active, agile decisions every day. We're not doing like Kanban boards. We're not doing leadership. Like the protocol exists, it runs, and we have a pile of value that we can direct as a group to help aid the overall message. That's much more like a city, and that's that kind of minimal, lack of direct financial tie-in, the lack of distribution of those profits from that organization. That is what allows, from a legal purpose, the justification that the government shouldn't know who those people are. If they were making money from it in large value, then you've introduced money laundering, you've introduced like tax evasion, you have a need, a justified need for the government to know who those people are. If you're building something else that doesn't have a direct flow of value to people, and we figured out how on the organizational side to cover that collective like risk as a group that doesn't identify people, then we've taken away the money laundering, we've taken away the tax evasion, we've taken away the problems and the risk. Then why do you need to know who we are? Why do you need to get inside of our privacy? And so that's what we're really setting up here, because in a land of fake AI, deep fakes, in a world where insurrection's considered by the government openly, is it really necessary for the government to have all of this power information over us? What we're talking about on some level is freedom. And so if you can get clear of some of that obvious like nefarious risk and get yourself to a place where we're talking about protocols, we're talking about speech, we're talking about the transfer of information, and we're not necessarily importing the entire financial world along with it, then we've opened up a different reality. And the technology that runs with blockchain is not necessarily Web3 only. Like zero knowledge proofs are going to be a huge role in this, like the blockchain being a slow, inefficient. I was at Berkeley listening to like the PhDs talk about this, the math people, and I don't try to understand, I'm incapable of understanding their level of understanding. But I appreciate expertise when I see it. And what they're saying is this is the foundational layer for providing a mathematical way of sharing information in a free society. This is the next step. This is essential technology for the development of the verification of information and the future of the internet. And that's what's exciting about this space. And so when I see like the speculation of profits, when I see the importing of old ideas as financial models, yeah, you can do that. But if you're going to do finance, then you should probably bring the same financial regulation that already exists to avoid the same harm that already exists. It's the area that's new, that's developing, where the technology solves some of these risks, so we don't need to bring that regulation along with it without considering, does that regulation help? Does it do anything? Does it protect anyone? Or has the technology solved that problem for us? And then do we need leaner, more targeted regulation? And that would be my answer of what we need to start doing, is getting our government to start taking this a little more seriously about the fact that the risk that they talk about is kind of antiquated for what the technology supports in terms of protections to its users.
Awesome. I think we can take questions from the community. Sorry. Yeah.
My name is Aditya. I'm working on a decentralized Twitter that's governed by a DAO. So 2 parts of the question. One is, what is a good time to create a legal structure for a DAO that's governed by? So that's one. And the second is, what could it be? So far what I've heard is 2 good options for a US entity. One is UNO, and the second is co-op. So which one of these will you suggest? Assume that most of the folks who are working today are in the US.
So my response is, first of all, can't give legal advice, so just generally speaking, there is a various amount of structures, so what we would do is look specifically at each DAO project and see where the members are based. Is there a token associated with it? What services are they doing? And the time to generally form an entity, I would think, would be as early as possible. So that would be my response.
I think I agree that the analysis that goes into deciding what type of entity structure, if any, should be used for a DAO is going to be nuanced. There's not necessarily going to be a one-size-fits-all answer, and I think sort of going back to this list of variables, right? David, I think some of the work that you did with Miles kind of lists out the various variables that each of these entity forms satisfies, right? And I think the way to walk through the analysis is to think, what's most important to you, right? What's most important to your community? Is it anonymity? Is it limitation of liability? Is it revenue sharing? Is it something else, right? And I think it's never a one-size-fits-all analysis. I think that it's really important just to keep all your options on the table, right? Because I think, especially in the legal world, it can become, just speaking very practically, right? Usually clients don't want to spend a whole lot of money coming up with some novel entity type, right? They want to do something that is quick and off the shelf and relatively inexpensive, right? And so that's good and that's understandable, but when we're in a new industry, that can also lead to a certain path dependency, right? You just do what's done before because it's easy. And I think that's problematic, right? I think when we try to do what's easy, then we fall into the same troubles that came before us because we're not really thinking about what we're doing. So I would say it just needs to be a really thoughtful analysis when deciding how you want to structure something.
Yeah, I think that's right. And I think it starts with a very challenging question to every project that no one really likes looking in the mirror on, is why Web3? Like, there's so many better entity forms, there's so many off-the-shelf solutions, there's so many other better ways of doing a business. So if you're trying to, reform a business model into the future, and you're using a DAO to do it because you see the opportunity to collect profits from, token sales or some form of token, that's not a good model. So if that's premised on why you're choosing Web3, then it's not a good idea. And so the question is, why are you in Web3? Why are you using a DAO? Why are you taking all of this difficulty, legal uncertainty, risk, and quite frankly, collaboration into effect if you're going to then delegate the responsibility to a centralized authority to replicate a business structure? Like, if you want to be a business, be a business. If you're running a business, be a business. The unknown factors of Web3, the unknown factors of decentralization, like that's not a way to take traditional business models and have them function independent of regulation. It's just a way to onboard just an absolute incredible amount of risk. So you really want to be careful that you're picking the right entity form, that you actually have a Web3 business and it's not Web 2.5, it's not something that shouldn't just be an LLC or a C Corp. And there's nothing wrong with trying to make money, right? There's nothing wrong with having profit as a motivation. It's just you don't want to be doing that as a token sale in a decentralized form with anonymous people. It's the combination of all of those factors. If you want to have a business that provides a service and sells it for revenue, good, that's America, we should do that. Just don't be a DAO.
We have another question here. We have only 5 minutes left, so.
Hi. My question is this. DAOs are created to achieve a certain purpose. So what happens if they don't achieve the purpose? So the case in mind is the constitutional DAO, where $47 million was raised. Unfortunately, they were outbid by this billionaire, Ken Griffin, for $49 million. So my question is, what are there legal recourses that these investors, the people that donate to the DAO, they can pursue against these creators to force them to return the money? And if they can you give specific cases that happened in the past?
I mean, I would say that's in no way under definition of a DAO is Constitution DAO a DAO. And so the way they had it structured was as a donative effort to the people involved were competent in the space enough to know that it was an opportunity for media to get profile, and it was fun. And they did it because it was fun, and it was a community effort. But if you were trying to actually seriously buy the competition, or buy the Constitution, one, the winning bid was a better example of how to do that. Two, this was set up as a raise, and it's a bad strategy to collect all of your money and then go try to buy something when the other side of your counterparty knows how much money you have. You beat it by $1. And so it was effective as a marketing campaign, it was effective as getting interest in it. But from a legal standpoint, none of that was set up under any other theory besides it was totally donative. So there are no options back because they knew what they were getting into. And if they had wanted to get out of it, they could have taken the refund. And so there's that whole like Second Life DAO that exists now out there where they tokenize the remainder of the unreturned funds. And that's not a project I'd want to have anything to do with from a liability standpoint because it's a whole lot of naked liability and not a whole lot of benefit. But there's not a ton of smart contracts. There's no protocol, right? Like if you look at the Constitution DAO, it is in no way autonomous. Right? They utilized some blockchain technology to use wallets to collect funds. But there was no protocol, there was no autonomy. It was decentralized and it was an organization. And it was nominally decentralized and it was an organization. And they set it up as a legal thing to avoid risk, and it was done in a way that didn't put anyone at huge risk. But yeah, I would say it was a fun project, and it leads off every major news story as an example of a DAO, and it's probably from a laying out the technical parameters of a DAO, it's just immediately dismissed as not. Uniswap would be a great place for news articles to start because that's a DAO and that's a protocol. And so if we could shift the narrative to more useful forms of DAOs than away from Constitution DAO, I think that would be in the best interest of the space because there's only so far you can take Constitution DAO in the realm of where the future of Web3 is going.
Awesome. All right, our time is up. I want to thank all of my panelists. Thank you so much for making this time and coming here. I want to thank the audience for listening to us patiently, and Oaks Project and Crossroads Conference. Thank you so much. You guys have a good rest of your conference. Thank you.